Good day, Crime Talk aficionados. My name is Scott Reich, and we have a great show for you. First, Bryan Kohberger just doesn't like to appear in court without his suit on. The Boulder King Soopers shooter gets sentenced today. Sarah Boone's 6th, 7th, and 8th attorneys had to go in front of the judge and grovel to get paid. Like father, like son, don't you hate it when the father brings some heat onto the kid? This day in legal history and our dumb criminal of the day. Let's talk about it.
All right, lawyer.
Good day, Crime Talk aficionados. My name is Scott Reich. Thanks for joining us. You know the drill. Subscribe if you haven't. Like if you do. Leave me a comment below and make sure you hit that little bell for notifications. And remember, you can check us out on any of your favorite podcasting apps. Now, it is a Tuesday, which means we're going to do our Tuesday night live show, 6 p.m. Mountain Time. Please join us. There's plenty to talk about. Obviously, we got Bryan Kohberger. We can talk about the King Super Shooter. We can talk about the Richard Allen case and the Delphi homicide case, which will be starting soon. And hey, maybe a little bit of Sarah Boone as well. Please join us. Before we get to the Daily Docket, please go to crimetalksearch.com. You're going to be happy that you did. When you go there, you can sign up for a background subscription service. You can do a background search on any number of people that you desire to do so here in the United States. You're going to get information about whether they have a criminal history. Are they on a public registry? Do they own property? Do they have judgments against them? Have they filed for bankruptcy? Are they married or are they divorced? If somebody new is coming into your life, go check them out. You're going to be happy that you did. And people that I've talked to have always been surprised by what they find out about people that, they just don't tell you about themselves because it's usually a little embarrassing. So if somebody new is coming into your life, check them out. crimetalksearch.com. All right, let's go ahead and open the record for September 24th, 2024. And first, Bryan Kohberger, for those who don't know, he's accused of killing 4 University of Idaho undergrads about 4 a.m. during a home invasion attack. And guess what? He is on trial for those murders and that burglary charge, and he faces the death penalty. And although he appeared a couple of times in his little orange suit there in Latah County, now he's in Ada County. So guess what? They have to make a new request to get him to have an appearance in street clothing. Why do they want street clothing? Well, his attorneys have filed a motion titled Motion for Defendant to Wear Street Clothing to All Public Hearings. They cite to a United States Supreme Court case going back to 1976, which recognized that the causing of a person to appear in front of his or her jury in jail clothing would impact the presumption of innocence. Mr. Kohberger respectfully requests that all public hearings be considered prejudicially similar. So, yes, the United States Supreme Court says you can't and you won't and you shouldn't allow somebody to go to trial in jail garb. I've only had that once because my client refused to dress out. And he also sat there and spun around when the prosecution was asking questions of his victims in his chair, a counsel table there. Let's just say it didn't go so well for him. But a defendant has an absolute right to dress out in civilian attire. But guess who has to do that? The attorneys. The attorneys are responsible to get the clothing, bring it to the jail, the detention center, have them dress out for those hearings. Usually it's only done in trial. I cannot think of a single time where I've had a client show up in civilian attire other than for a jury trial. Sentencing, nobody matters. Pretrial matters, nobody cares. Why? Most jurisdictions are busy. They simply don't have the time to do it. All right? And in this particular case, the attorneys for Bryan Kohberger have spoken with the sheriff, and the sheriff says we can do this if it's authorized by the court. I don't know. Seems like a waste of time and resources, but the defense says it's going to prejudice Mr. Kohberger, particularly because the new booking photo was released to the public, and now they're going to see him in his jail garb. Really? I mean, I get it. We want to have a clean trial. We want the presumption of innocence. I get that. But the reality of it is, ladies and gentlemen, if you've ever done a homicide trial, I've done many, couldn't even tell you how many I've done. But the reality of it is that it's a homicide trial. And everybody in that courtroom, including the jury, is going to know that he's in custody. Why? Because if you're charged with murder, you usually have a no bond hold or a bond that is so high that you'll never be able to make it. So yes, I get it. We want to try to engage in this legal fiction that nobody's ever going to know. All right, like I said, Kohberger has 4 of those felony charges for the murder and then felony burglary. The prosecution is saying they are seeking the death penalty, and obviously the defense is trying to avoid that. We'll have to wait and see. We have hearings coming up shortly in that case. We'll bring it to you live. Next on the docket, the Boulder King Soopers shooter gets sentenced. All right. So the gunman who killed 10 people, that's right, 10 people at a Colorado King's Soopers, which is a supermarket here if they don't have them in your area, just up the road here from the CrimeTalk studios in Boulder, Colorado. Well, guess what? He has been sentenced to life in prison for murder after his family told the court that they thought he was possessed by an evil spirit. Well, Ahmad Alyssa attempted to avoid prison time by pleading not guilty by reason of insanity, and the jury shot those defenses down big time. He was found guilty of all 10 crimes, plus a bunch of sundry of other counts as well related to firearm offenses, as well as to people that were only injured and not killed in the case. So defense attorneys didn't dispute that Alyssa had schizophrenia, fatally shot 10 people, including in killing a police officer. Now, on the day of the attack, he drove from his home from a suburb here in the Denver area called Arvada, and then pulled into the first supermarket that he found in Boulder, and he shot 3 victims in the parking lot before entering the store. Now, there's an emergency room doctor that was in there that hid and told his story throughout the trial. We had a pharmacist who took cover, and she testified that she heard Alyssa say, "This is fun," at least 3 times as he went through the store firing his rifle. But the defense argued that he was insane at the time, and therefore he couldn't tell right from wrong. Well, like I said, he's one of the latest people. We talked about the lady in Mississippi yesterday who failed in their attempt to be acquitted by reason of insanity. So like I said, in addition to the 10 first-degree murder charges, the jury found Mr. Alyssa guilty of 38 charges of attempted murder, 1 count of assault, and 6 counts of possession of an illegal weapon, and including the large capacity magazine. We've seen that more and more here in Colorado. Anyway, Judge Ingrid Bakke, who is tough, career prosecutor, was one of the prosecutors on the Kobe Bryan case. She was on loan from Boulder, where now she is the judge. I believe she's actually the chief judge. Like I said, sentenced him to 10 life sentences without the possibility of parole, and another 1,334 years for all the other charges. Why? Because they were considered crimes of violence, separate victims, although the same offense, separate victims, shall be sentenced consecutively, and therefore that's how you get up to that additional 10 life sentences plus 1,334 years, which means obviously he will never, ever get out. The judge told Mr. Alyssa this was not about mental illness. This was about brutal, intentional violence. Mr. Alyssa declined to make any statement through his attorneys at all. As noted at the sentencing, the prosecutors stated that Mr. Alyssa killed most of his victims in just over a minute, and then he surrendered after a police officer shot him in the leg because he needed medical assistance. Now, at the trial, the prosecutors had to prove that Alyssa was sane, right? It was an affirmative defense of guilty by reason of insanity. Affirmative defense saying, I did it, but I was justified. Or in this particular case, I had an excuse. So the prosecutors had to prove, like I said, that he was sane. Now, they argued he didn't fire randomly, and he showed an ability to make decisions by pursuing people who were running and trying to hide from him. Because there was video where he showed he twice passed a 91-year-old man who continued to shop who was unaware of the shooting. Now, he came armed with bullets and obviously large capacity magazines holding 30 rounds, which prosecutors said showed he wanted to make the attack as deadly as possible. Now, during deliberations, the jury asked to review the videos of Alyssa killing the victims, complying with the commands as he was arrested, and later being interviewed by a psychologist. Now, like I said, the family said he had mental health issues. Now, Mr. Alyssa was diagnosed with schizophrenia after the attack, and experts said the behavior described by relatives were consistent with one that had the onset of schizophrenia. Now, psychologists who evaluated Mr. Alyssa throughout these proceedings concluded that he was sane during the shooting. And guess what? The defense did not have to provide any evidence and did not present their own expert to say that Mr. Alyssa was insane. All they do is raise the defense, then the evaluations take place, we have a trial. So despite the fact that he heard voices, the state psychologist said that Mr. Alyssa did not experience delusions. They said his fear he could be jailed or killed by police revealed that he knew and was aware of his actions. Mr. Alyssa repeatedly told the psychologist that he heard voices, including killing voices, right before the shooting. But Mr. Alyssa failed during about 6 hours of interviews to provide more details about the voices or whether they said anything specific. Now, mental illness is not the same as being insane. Colorado law defines insanity as having a mental disease so severe that it is impossible for the person to tell right from wrong. I'm telling you, not guilty by reason of insanity does not work very often. I can think of only one case that I've been able to have it be successful, and it was so obvious during that particular case, the prosecutors agreed, and we sent the defendant off to the mental health hospital. But it's very, very tough when you can show planning and you were aware of the consequences. That's not insanity. It's just, you don't like being caught, I guess, at this point anymore. Next, the court made Sarah Boone's attorneys grovel for their fees because of, well, Sarah Boone, I'm sure. So Sarah Boone's 6th, 7th, and 8th attorneys had to appear in front of a judge and had to lay out the difficult work conditions that they were asked to do in order to get paid for their work. So Frank Bankowitz, Winston Hobson, and Patricia Cashman all told the judge about the extreme amount of work they did representing Sarah Boone, describing it as taxing every fiber of their bodies. Now, Bankowitz, Hobson, and Cashman also noted that behavior during the hearings on Tuesday and told the judge that while they had only represented Ms. Boone for a portion of her case, they had put in hundreds of hours of work. So, for example, Bankowitz, who represented Ms. Boone from July of 2022 through September of 2023, and ultimately withdrew from the case or was allowed to be relieved from the case after Ms. Boone referred to him as a dud and a buffoon, said that he had worked 175 hours on the case. Hobson, who replaced Bankowitz, only represented Boone until February of 2024 and said that he had spent a tremendous amount of time with an investigator and experts in the case. And Hobson said the expert was never used because Boone didn't like her. The attorneys relayed that, I would say conservatively, that any lawyer that had this case could tell you easily they spent at least an hour or two on the case every single day, gathering information coming in from Ms. Boone, the matters that she wanted dealt with, her view on the law versus the theory of the case, and apparently it was a constant battle going back and forth. Gee, I've never experienced that before. And the attorneys explained that you had to deal with the gaslighting, and they explained to the judge it was just too much, not worth it. Cashman told the judge that her work in the case included having to watch basically TV to keep up and see how this would possibly affect the potential jury in the case. She also noted that the defendant's propensity to write letters to the court certainly complicated things as well. The judge allowed Cashman and Bankowitz a $15,000 flat fee. Hobson was awarded $15,000 for the hourly fees that he had worked. So you've got 3 attorneys in about a year that spent $45,000 at a significantly reduced rate because Miss Boone couldn't get along or cooperate with their attorneys in any way. Now you see why the judge found that she had forfeited her right to court-appointed counsel. I totally agree with this. Now this new guy that's on the case thinks he's going to get paid somehow. I guarantee you Ms. Boone is running this guy through the grinder as well. And if he doesn't withdraw, he's going to wish that he had never got on the case. And I'm sure that if Ms. Boone is convicted, she will say that he was an ineffective buffoon. Ms. Boone's trial is scheduled to begin on October 7th. Final pretrial hearing is September 26th, so it's coming right up. Next, a family that does time together stays together. It's lovely. You know, when you can have multiple generations in the same facility, you know, it just says, I've raised you right, right? Well, the son of the would-be Trump assassin, Ryan Ruth, has been taken into custody on federal charges of, guess what? Possessing child pornography. Now, police seized multiple electronic devices from the 35-year-old Orlin Alexander Ruth at his home in Greensboro, North Carolina on Saturday. And the investigators say that they have found hundreds of files with child exploitation material on those computers and disks. The illicit material was discovered during a search conducted in connection with the investigation unrelated to child porn, because they were looking at his dad, who tried to kill the president in Florida. So the younger Ruth has been charged with receipt of child pornography and possession of child pornography. And investigators were at the house in connection with the investigation of the father, Bryan Ruth, who was arrested on September 15th after he was spotted trying to shoot at the president. Wasn't successful, ran away, etc. You know the rest of the story from there. Anyway, the FBI conducted the search of the younger Ruth's home on September 21. As part of that investigation, they confiscated several electronic devices, including a Samsung Galaxy Note 9 device. And after they obtained a warrant to search the electronic devices, yep, that's right, they discovered all that kitty on there. Can you say going to prison? Yes, he is. Unless you can say they had no basis to get that particular device, it's going to be a tough road for the younger Ruth. Maybe he can share a cell with his dad in federal prison after he's convicted of attempting to kill the former president, Mr. Trump. Next on the docket, this day in legal history. On September 24th, 1789, Congress instituted a three-tiered federal judicial structure topped by a Supreme Court with the passage of an act to establish the judicial courts of the United States, later known as the Judiciary Act of 1789. Yes, helped create the district court, appellate court, and then obviously the Supreme Court is there because of the Constitution. Article 3 of the Constitution, hence the name Article 3 judges, right? Not an administrative law judge, not a state court judge, an Article 3 judge, which means you have your power coming from the United States Constitution. Now you know, ladies and gentlemen. And then finally, our dumb criminal of the day. Now, we've seen some very dumb criminals in our days here at CrimeTalk, some very unintelligent ones, no doubt. But take a look at these three idiots. They carjacked a vehicle, then dumped it at the Pentagon in Washington, D.C., thinking that they were going to beat this rap. After all, it's one of the most secure installations in the United States. It allows some public access, but you got to think it's not a good place to ditch a stolen car. So these three kids, all in black, including their hoodies, running through the public parking lot. You can check it on the video here. Back on September 1, like I said, they hijacked this Toyota Highlander in the D.C. area at gunpoint, and police were hot on the dumb kids' tails as they decided to pull into the public parking lot there at the Pentagon. Authorities believe the plan was to catch the metro rail or bus slipping away from the cops. But their choice of location came a little more complicated because, well, they got the Pentagon Protection Force Agency, the police force, for the Department of Defense, and their sole purpose is to protect the Pentagon. You'd think they'd have it pretty well covered, which they did. Well, like I said, these three little thugs with a handgun park the stolen car in the parking lot, start running towards cover. Ooh, doesn't work so good, though. Guess what? They even had a helicopter. You can see and hear a helicopter overhead and sirens in the distance as they are swarmed by law enforcement. Guess what? All three were arrested, but since they're juveniles, we don't get to know their names, and they've all been charged with the armed carjacking, ladies and gentlemen. Armed carjacking. You, three gentlemen, are our dumb criminals of the day. Congratulations. Somehow I think this may be just the first of many dumb criminal awards for those three. All right, that's all we have for you today. Thanks for joining us. Join us tonight, 6 p.m. Mountain Time, for our Tuesday night live program. Thanks for watching. Remember, the Constitution matters.